Let's discuss with two straight shooters, two people I never know exactly how they're going to come down, which is why I like having them on. Renato Mariotti, former assistant U.S. attorney for the Northern District of Illinois, and Sarah Isgur, former spokesperson for the Department of Justice under President Trump. She's an attorney and ABC News contributor and the host of the legal podcast Advisory Opinions. All right, so Sarah and I actually talked about this in the green room on Sunday at ABC. So I'm going to start with Renato on this. Renato, what do you make of my point about the hypocrisy in the two cases? Am I making a fair comparison, or do you think comparing the cases is unfair?
I think it's fair. I think the Biden case is a little complicated in that I think it's a case that I agree there's no defense at trial. There may be some appellate victories for them. I think that's part of the reason that they're going forward with the trial, is to preserve their ability to make those appellate arguments and, frankly, to buy some time for an eventual pardon, perhaps. I wouldn't be surprised. So I think there's a defense strategery going on there where there maybe wasn't in the other case. But otherwise, yeah, I agree with you that both cases are rather one was complicated, and I'd say the Trump case was a very complicated case that I think there's good arguments that it should not have been brought. I think very questionable in that regard. The Hunter Biden case is straightforward, but for totally different reasons, would not have been brought if his name wasn't Biden.
Right. Well, that's what I was going to ask. Just bottom line, do you agree with me that the Manhattan case would not have been brought if the name wasn't Trump, and this case wouldn't have been brought if the name wasn't Biden?
I agree.
Okay. Now, I know Sarah agrees with us on that because Sarah and I talked about this at length. So, Sarah, let me ask you about the defense here. I want to read you some of what Abby Lowell is saying about what the defense is going to be. The issue here is Mr. Biden's understanding of the question on the form, which asks in the present tense if he is a user or addict. The terms user or addict are not defined on the form and were not explained to him. Someone like Mr. Biden, who had just completed an 11-day rehabilitation program and lived with a sober companion after that, could surely believe he was not a present tense user or addict. What do you make of the defense?
Well, they've got some problems there. In his memoir, of course, around that time, he's saying he was smoking crack every 15 minutes, 24 hours a day, 7 days a week. But maybe more importantly, he's also charged with possession of a gun while using a controlled substance. And the DOJ actually said in one of their filings that investigators literally found cocaine residue on the holder for the gun. It's going to be very hard for him to say that he was not using cocaine while in possession of the gun.
Right. So do you agree with Renato that this is really just an effort to punt to some degree until after the election so Biden can pardon him no matter what happens?
I agree that his father is not going to let him spend a day in federal prison. The sentencing guidelines here would recommend 10 to 16 months on just that one possession charge. That's a year in prison. I'm confused why he's not taking a conditional plea, meaning he would plead to the facts, avoid an embarrassing trial that could be politically harmful to his father, but just say, let's skip the trial. I agree I did all those things, but I'm going to challenge the constitutionality of the law. We've seen the Fifth Circuit hold that someone pulled over while having a gun and a joint in their car. The Fifth Circuit hold that 922G3, the charge here, was unconstitutional as applied to that person. Of course, I think cocaine is different. I think the cocaine residue situation is different. But still, he has some legal grounds to challenge this law.
Renato, what about the fact that Jill Biden is sitting in the front row of this case, both legally and politically? What do you make of it?
Well, I don't know about politically, but I think Abby Lowell thinks he has a shot at winning. I think he thinks he has, by win, I mean a hung jury. Okay, I'm not saying that he's going to get not guilty. But to me, on the defense side, as a defense attorney, that's a win. Okay, if I get a hung jury, that's a win. Yep. And I think he's thinking that there's going to be some jurors there are effectively going to nullify this because they're going to say this is they're going to feel bad for him. It's BS, and who knows how people there in the jury pool are going to feel about the Bidens, and he has a shot of winning this. So
but that's exactly what Sarah and I thought was going to happen in the Trump case. I know you didn't, Renato. You predicted there'd be a conviction. You did. And people said to me, Dan, are you going to admit you were wrong? Of course, I admit everything. I'm very transparent. I said I thought there was going to be a hung jury, but for the exact reasons you're saying here in the Biden case.
But if Abby Lowell was trying that case for Trump and Trump just shut up and listened to what Abby Lowell told him to do, he would have achieved a similar result.
I don't think so.
The problem was poor lawyering and a legal team that was listening to their client instead of actually mounting a credible defense.
I don't know. Sarah, final word on that. You think it would have made a difference?
I don't think so. I think this is what Robert Jackson warned us about, the Attorney General from 1940. He said the most dangerous power a prosecutor has is picking who they go after, not the crimes they go after. And that's both of these cases here.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.